Good afternoon. It is a pleasure and privilege to be here. Many thanks to UBRI and Ripple for inviting me to share the results of our research on the regulation of digital asset markets and crypto enforcement. So let's delve into the slides. Next slide, please. I'm going to present on something that I call the tetralogy. What does it mean? It means 4 studies which lead to one simple conclusion. And the studies were completed by my research team, my co-authors, and I over the course of 1.5 years. The conclusion is as follows, and it's very simple. There is a clear need for a formal rule for digital assets and crypto asset market infrastructure. In this presentation, I would like to focus on one single agency, which is incredibly important in crypto markets, and it's the SEC, or the Securities and Exchange Commission. So what is the strategy of the SEC in crypto? It's regulation by enforcement. And has the regulator achieved the intended outcomes, as I will describe today? Not really. To give you the background of what the SEC enforces, there are several security statutes, with the Securities Act and the Exchange Act being the major statutes, and they're all animated by 2 approaches. First, providing investors with adequate information, and secondly, supporting not only market efficiency, but also investor protection. Next slide, please. The SEC is unique in many respects. First, it operates in an environment where there is no clear crypto rule. Instead, the SEC relies on all those statutes that I've just mentioned, which are more than 90 years old in some cases. And secondly, the SEC relies on the so-called functional tests. What do I mean by that? About 80 years ago, the Supreme Court in the Howey case developed a new test for esoteric securities, which didn't fit within the known universe of securities such as shares of stock or bonds or notes. Consequently, the Howey test is very capacious, it's functional and imprecise, in order so that, let's say, market regulators and courts could apply to a variety of financial instruments. And this is what the SEC and courts have been applying ever since, and in particular in the case of crypto assets or digital asset securities. In this sense, the SEC is different from other countries and other regulators. There are some studies which suggest that the crypto market reacts negatively to news of formal regulation. But those studies ignore that the US and the SEC are unique. Next slide, please. Now, let's talk about who was affected by the crypto enforcement and this regulation by enforcement. Multiple parties, including even one attorney. Broker-dealers, crypto exchanges, crypto-related firms, issuers, all of them have been affected and were in the SEC's crosshairs over the course of the 4 years from 2017 through 2021, 4 years of the SEC crypto enforcement. Where were those parties from? Multiple countries, including mostly the United States, of course, but also foreign jurisdictions. And if you look at the fines and disgorgement orders, they were massive. Next slide, please. How did the SEC proceed? The SEC proceeded through what I call heavy weaponry. Specifically, it deployed courts and administrative proceedings, or in other words, it's initiated actions in federal district courts and in administrative proceedings in-house against 2 categories of cases. Number 1 was issues related to fraud, which is very beneficial to the market. Why is it beneficial? Because markets generally value integrity and trust. Consequently, fraud should be rooted out, and the role of regulators is seen positive in this respect. The second category, however, was different. It was cases related to simple registration provisions of the security statutes. And let me give you an example. One registration provision would be when an issuer/developer wants to sell digital asset securities. But they don't realize that what they're selling are securities. Consequently, they do not register them with the SEC. Another example, Take the first crypto exchanges, Uniswap, for instance, a more recent example, or the early crypto exchanges such as EtherDelta, whose developer did not realize that what he was launching was a crypto exchange, a securities exchange, which was supposed to be registered with the SEC. So there was no fraud involved in those cases. And we can see this bifurcation. If you look at the chart, next slide, please. We have the blue bars, which denote those simple registration-related violations. Let's process it. We have fraud and non-fraudulent cases. Plus, we have a massive enforcement program. Next slide, please. But the market reacts negatively to this enforcement program. Next slide. And these are the results of the study that I'm completing right now with Irina Hutton of FSU Business School. We looked at all the enforcement events in the past 4 years and compared them with market returns. And we can see that cumulative abnormal returns are uniformly negative. Next slide, please, slide 9. If we look at this cross-section of bifurcation that I mentioned previously, specifically we have fraud and non-fraudulent issuers. Fraud is negative. It's supposed to be prosecuted. And non-fraudulent issuers, however, simply make mistakes. It is possible, our hypothesis was that the market would welcome fraud-related prosecution and not welcome or welcome not so much non-fraudulent cases. But unfortunately, there is something else going on. And it's really hard to pinpoint what is happening. The market reacts negatively to both fraud-related cases and non-fraudulent cases. Next slide, please. And the reaction is particularly negative when it comes to such market actors as crypto exchanges and various types of issuers. And in the last line on this slide, you see ICO issuers. This is slide 10. By ICO issuers, I meant everyone, including STO or security token issuers and other parties. Next slide, please. So we have this puzzle, this dilemma. The market uniformly reacts negatively to crypto enforcement. This dilemma would not be that important if everyone else, every other regulator in the world, did pretty much the same. Next slide. But when we looked at how the SEC fared compared with other jurisdictions, and you can see this huge table on slide 12 right now, the SEC is number 1. And these are the results of a study which was published in May this year in the Southern California Law Review. I finished it together with my co-author, Professor Douglas Ickley of Rutgers Law School. We can see that the US SEC brings court actions and administrative actions, while other jurisdictions are satisfied with a light touch approach, including warnings and blacklists. Next slide, please. And next slide. Now, let me summarize the strategy. Now we're on slide 14. In summary, there is no clear rule or regulation, an updated rule or regulation on crypto assets and crypto market infrastructure. There is that functional test, the Howey test, which is still applied to crypto assets, and the SEC is number 1 in the world in terms of enforcement intensity. What are the reasons behind this enforcement strategy? The reasons are protecting investors and providing markets with information. Quite beneficial, right? Alas, the market reacts negatively to enforcement. Next slide, please. So, how to approach this puzzle? How to solve it? At first, in my recent study, which was published in the Journal of Corporation Law in June this year, I tried to apply a game theoretic approach. If we look at Howey, which is very functional, capacious, exceptionally broad, and imprecise, and if we juxtapose it with the fact that market actors value regulatory clarity, it is clear that this certainty may come only through enforcement under the circumstances. So enforcement can be an effective regulatory tool, but it can be effective provided there are 2 conditions. First, it is dynamically consistent, and secondly, it is predictable. And by analyzing the whole enforcement program, the all 4 years, I noticed that there was a watershed moment in around mid-2019. Specifically, in the first 2 years, the SEC pursued a consistent, a predictable strategy. And then there was a pivot, a shift, if you like, which we can see in Kik, Telegram, and to some extent the Ripple case. The SEC's program lost its predictability. Next slide, please, slide 16. Now, dynamically inconsistent and unpredictable enforcement may destroy the cooperative equilibrium where private parties are trying to cooperate with the regulator and to comply to some extent. Put differently, if no one expects anything from being a good citizen, that firm may forgo compliance altogether. In the alternative, it will resort to perfunctory compliance. Next slide. And this seems to be indeed what has happened. And let me present the results of the 4th study in the Tetralogy. And this one is forthcoming in the Stanford Journal of Blockchain Law and Policy. It looks like the SEC may have pushed issuers, at least issuers of crypto assets, and this is the case study for this article, at least issuers toward the least costly compliance option, which is private placements on Form D and private placements under Regulation D in general. And this is not very beneficial to the investors because private placements, they provide less information to investors, and there are no mandatory disclosure regulations in most cases. Recall the SEC's objective, however. We want to provide markets with material information. We want to provide markets with meaningful information and promote market efficiency while protecting investors. This doesn't seem to be the case. Next slide, please. And next slide. I wanted to show you the connection between the first enforcement actions, which started in approximately 2017, and the rise of private placements on Form D. You can see that blue line, which indicates that firms began to file Forms D more and more often. In fact, there have been only 4 cases where firms provided some disclosure to investors under Regulation A, which is commonly referred to as mini public offerings exemption. And there was one successful public offering on Form F1. So, next slide, please. It looks like the status quo is as follows. Issuers attempt to comply. How do they comply? They comply based on Regulation D, which is their weapon of choice, meaning private placements, which lack comparable and material issuer disclosure. Investors, they seem to react negatively, as we saw in the general market reaction. At the same time, we need to bifurcate the investors into 2 subtypes. The first one is the sophisticated investors who do not really care about SEC enforcement and are not ready to reward issuers for disclosure based on the rules that the SEC attempts to disclose. Why? They're sophisticated enough, they can read the code, they understand the code, they have access to alternative data feeds. By contrast, we also have the unsophisticated, and those do not understand the code, and they would have benefited from comparable material issuer disclosure, and yet this is not what they received. Next slide, please. At the same time, the SEC continues to bring enforcement actions for non-compliance with pre-crypto statutes, insisting that they do that because investors do not receive material information. They don't receive it anyway in the current status quo. Slide 21, please. So the main problem is that we need to solve the information asymmetry problem at the moment. We need to provide issuers with low-cost compliance options, which would give them an incentive to comply. And we need to ensure relevant, standardized, comparable, and mandatory disclosure regulations for the crypto asset market. To date, I believe there is only one proposal, which sort of checks every box. And this proposal was advanced by Commissioner Peirce back in April this year. And last week, on the 4th of October, it was introduced, a variation of it was introduced as the Clarity for Digital Tokens Act of 2021. Next slide, please. So to conclude, what we have is the following. First, the market reacts negatively to enforcement. The enforcement of what? Enforcement of pre-crypto rules based on functional tests such as Huawei. This implies that the market perceives enforcement as costly. And the crypto asset issuers, they attempt to avoid full compliance with the security statutes through resorting to exemptions from registration. This is their most rational option. Alas, that option results in higher information asymmetry and lower disclosure comparability, which suggests that a formal reform is needed. Thank you. And now we have some time, I believe, for questions. I don't see them in the chat. Well, since we have no questions, thank you very much, and back to you in the green room.